Good evening, friends. In this video, we're going to deal with the issue of medical treatment, consent for medical examination, and the two-finger test in context of child sexual abuse and rape cases. As far as emergency medical treatment is concerned, please note that every child and adult woman has the right to medical treatment. Any hospital, government or private hospital, is duty bound, legally bound to give emergency medical treatment to survivors of sexual violence. This is reflected in the law post the Nirbhaya case, and if they don't give this treatment, emergency medical treatment, they can be prosecuted under section 166B of the Indian Penal Code. The second issue is about medical examination. Section 27 of POCSO deals with medical examination for children. And it's clear here that children have a right to medical treatment and medical examination. There's no need for a FIR to be filed for a child to get a medical examination or medical treatment. Please note that the consent as per the Criminal Procedure Code requires anybody above 12 to give consent. If you're under 12, then it's your parent or legal guardians who have to give consent. If you have some sort of disability whereby you are not able to give consent, then again it will be your legal guardians who will give consent on your behalf. Otherwise, if you're 12 and above, the doctors cannot carry out a medical examination without your consent. This is particularly important in adolescent sexuality cases where the main evidence against children is usually obtained through the medical examination. The third and last thing I want to deal with in this video is the two-finger test. So this is a vaginal examination to look at the elasticity of the hymen and determine whether somebody is a virgin or not. And if it's a child, it's assumed that the child is a virgin, and if they're no longer a virgin, then the rape or sexual assault has happened. This practice is totally not allowed to take place anymore. The Supreme Court has said that this violates the privacy and dignity of the woman or the child to whom the two-finger test is being done. And primarily, apart from the privacy and dignity point, it's also totally unscientific. There is not insufficient proof to say that this is a scientific way of concluding that the person is a virgin or not. So for that reason, the two-finger test doesn't work. The police are the ones who have a duty to take the child or adult woman for medical examination within 24 hours of the rape being reported to them. The practitioners, the doctors, have to collect the forensic evidence as well as note down all the evidence that the person gives them about the incident, their age, address, details of incident, medical conditions, etc. They also have to see whether the child is, if there's a risk of the child being or adult woman being pregnant, and also risk of sexually transmitted diseases have to be checked. The forensic evidences obviously can be very important in cases where the police have managed to get the child or the adult to the hospital within about 36 hours. After that, it's very difficult to get the forensic evidence. Another important point about medical examination of children is, as in every other stage, the medical examination process has to be child sensitive and child friendly. In case of girls, it has to be done by a female doctor. There's no choice. It says it shall be done by a female lady medical doctor. And sometimes that's not being done still. And the other thing, of course, is that the child has the right to have a person that they trust with them, usually their parent. But of course, in a case where the parent is not supporting the prosecution or is not available, it has to be somebody else, either appointed by the head of the medical institution or somebody that the child trusts. Both these points are very important. Also, please note, in disability cases, the special court can appoint experts to ensure that the child can give their evidence, their best evidence. Where that step has not been taken by the police or the magistrates, when the 164 statement is recorded, the special court certainly has the power to appoint language experts and disability experts. This was done in one of our cases to great effect. I am very sure that in that case, if the court had not appointed an expert, the victim would not have been able to give her best evidence. As it was, she gave her best evidence and there was a conviction. So it's very important for the court to be aware of this, and for the people before the court to apply for an expert where that's required. Thank you.